I want to thank you for your service in this case. It's been a long trial, going over a week. Well, some of this testimony you may be getting in piecemeal and you think it's tedious and you don't understand what's going on. Well, that's trial work. It comes from all different sources. Mr. Carroll and I have to do the best jobs we can for our clients to try to present this to you in a manner that you understand. If it's sometimes I did something that may have upset you or made you think, what is he doing? I apologize for that because I don't want you to hold that against either party. And I want you to understand what this case is about. The other thing I want to do is publicly apologize on behalf of myself and my client to Mr. Mark Oziel. Mr. Oziel was treated very poorly in this court. Did the dean and her counsel respond to his testimony that he recommended?
Yeah, that's entirely inappropriate. You can comment on the substance of his testimony, counsel, but the way he was treated is not subject to argument. You should ignore any comment he made about Mr. Oziel. You can take his arguments about what the evidence did or did not prove, but as to how he was treated, that's entirely not your concern.
Mr. Oziel came in and, being a 20-year member of this faculty, exposed this faculty and the dean to what they really are. Liberals who won't listen to other sides of the story, who he got fed up with them because time and time again, candidates that he felt were qualified and should have been selected were not by this liberal faculty. He showed the liberal bias that exists among this faculty and that they have time and time again denied conservative candidates who have gone on and done well and gotten good jobs. In fact, one went to the University of Chicago Law and received a good job. Did they respond to his testimony that he made complaints to the Iowa legislature regarding the unfair hiring practices 9 years ago? No. Instead, we hear an unfounded allegation that Mr. Oziel supposedly had engaged in sex acts within his office with the door closed. Look at that. It was unfounded. They didn't have any evidence admitted in this case that said that actually happened. That, in fact, Mr. Oziel said I was doing my exercises to overcome an arthritic hip as the result of what was going on. Now, they investigate Mr. Oziel for a false allegation that turns out unfounded. But what does Dean Jones do in this case in the face of John Carlson's email? All she does is talk to him. There's no investigation done at all. When Mr. Carlson sees that there is a severe concern in his mind that politics may be held against her, she does nothing other than say, what do you got? When she said in her direct examination that I was policing this because this had been brought to my attention by both of my associate deans. And then she attends a job talk in which Mr. Bazanzin says, we talked about her politics. We may have talked about her politics. Is that the police force that you want in this type of case? I submit not. She doesn't even talk to her other associate dean, Eric Anderson, the only Republican on this entire faculty, and doesn't do anything else to investigate. She admits in unusual circumstances or in circumstances that she sees something wrong, that she can step in and do something, but she did nothing. I also need to tell you one thing else about discrimination law, whether it's race, whether it's sex, whether it's national origin, whether it's disability, whether it's age or whether it's politics. It's insidious. Nobody's ever going to come into this court of law and admit that I'm a racist, that I'm a sexist, that I'm against a national origin, that I'm somebody who doesn't like the disabled, that I'm someone who doesn't like conservatives. If they did, they'd be stupid. Just as Mr. Bezanson said in his deposition testimony. He said, nobody is ever stupid enough to say anything about Miss Wagner's politics at a faculty meeting. The Supreme Court has recognized that it's very rare that an employer comes out and says, we're not going to hire someone because of illegal means, namely whether they're black, old, a female, disabled, or because we don't like their politics, or because we so despise her politics. This is that very, very rare case where that actually happened. They were not stupid enough to say something about Miss Wagner's politics. They were stupid enough to do that, and that's Mr. Bezanson's admission. But I also hope you caught in direct examination with Carolyn Sheeran, who certainly seemed hostile to my client, that she admitted when questioned by Mr. Carroll in direct examination that they were, at the time of the job talk, someone had mentioned to her that Teresa Wagner was pro-life. That's contrary to basically every female witness, including Dean Jones, who has testified in this case. Every one of them has admitted that she's a conservative pro-life person, and every one of them have admitted that they all have different views of that. And in fact, one of the witnesses, Miss McGuire, was a board member for the Emma Goldman Clinic. That is as far different from what Miss Wagner believes than what the majority of this faculty believes. In fact, I spent a lot of time with the different witnesses, including Associate Dean Carlson and Associate Dean Anderson, and asked them, isn't it supposed to be a faculty that approves all different types of viewpoints? In fact, Mr. Bonfield, who was really, really an entertaining man, I thought, after 51 years of being at the law school, said that when he teaches con law, he's supposed to do that. He's supposed to take the other side of the argument. And he gets upset with his students when they don't do that. Well, in practice, at this law school, there's no conservative female voice on the faculty at all. Every single one of the witnesses admitted that that was an underrepresented person on this faculty. So, you heard Mr. Bonfield say that he would have gone through the roof if he heard this. But he also heard Mr. Bonfield disassociate himself away from the liberal Matt Williamson. I didn't go to his job talk. I don't remember his resume. I don't think anything of him. I didn't form an opinion. Well, you saw in reality that he did go to the job talk, that he did support Mr. Williamson. In fact, he said he was excellent. We should hire him. And yet, he comes into this court and tries to convince you that we hire only on merit. And we don't hire, and we don't recommend to the dean anything that's affected by politics. That's incredible. In this case, after you've heard all the testimony, after you've heard all the arguments, and after you've seen the contemporaneous documents that existed at the time that she was first considered for the full-time position, and then subsequently, when the dean herself invited Teresa Wagner to be an adjunct, and yet she comes into this court now and tries to convince you, Oh, I was against that candidacy too. You saw the email from Mark Janis that said the dean has asked me to ask you whether you would consider doing this. Why would a dean of the law school invite my client to become a part-time or adjunct instructor if she thought her bombed answer that she would never teach legal analysis ever was what she actually said? Common sense says that didn't happen. And common sense says that they were talking about her politics the day before with Mr. Bezanson leading the charge because he was the person opposed to her candidacy. Mr. Bezanson was a pro-choice advocate. Not only was he a pro-choice advocate, he helped write the opinion that resulted in the approval by the United States Supreme Court of abortion, legal abortion. If you think that Mr. Bezanson was going to put that thing that he was quite proud of doing in part of his career on the back burner and not let his politics and the rest of the faculty's liberal politics affect this decision, you're wrong. Because it's true. People tend to side with people they like. This faculty is not diverse in any manner when it comes to politics. And you can see that from all the witnesses that they brought in. It's also a rare case where we actually have a smoking gun email from John Carlson saying he does not understand the opposition even to Teresa as an adjunct, and the only thing he can come up with is that they opposed her because they so despise her politics. This is an email written at 4:55 a.m. after the faculty vote to offer Williamson a full-time position and reject my client, despite the fact that there's 2 available full-time positions that they needed to fill. Don't park your common sense outside this courtroom. Why, in this situation, where we have no recording of what they discussed in this faculty vote, we have no indication of who voted for whom. We have no indication what the dean said. This is all secret ballot, guys. This is all, we can hide behind our secret ballot so that we don't have to tell you what we actually really discussed. That's good circumstantial evidence. And to get Mr. Bezanson to have admitted it is, quite frankly, I give the man credit. He told the truth. He actually said, yeah, we do that. Nobody could say what was said at that meeting other than Mr. Bezanson recalling that. We also have the statement from Mr. Carlson that there's an undercurrent of opposition. That's precisely the form discrimination takes. Nobody comes out and brings it up to the surface of the water. Nobody pops their head out of the undercurrent and says, I'm a bigot. Nobody comes out from underneath the water and says, I hate or despise her politics. But there's that undercurrent where they all sit at the lunch table and they all talk about their liberal views and they all say, she's not our type. She doesn't meet what we have as a homogenous group here. She had an undercurrent of opposition, which this associate dean, who'd been there for 30 years, recognized and wanted to make sure didn't affect the whole process. We also proved that simply by looking at her resume, they knew she was conservative. Dean Anderson admitted that. He told Teresa that. He said, they all knew your politics. It's right there on your resume. He also then when he was telling her that she didn't get the job, the full-time job, well, the faculty didn't consider your politics. It was right there on your resume. No, it was because of your job talk. Cover up. That's all that is. He's making excuses for his faculty that he knows are blazing liberals. And he knows that his blazing liberal dean also participated in that faculty vote where they all sat around and talked about her politics. So what does he do? Well, as a good defense attorney, he tries to dissuade her. He tries to tell her, oh, that didn't happen. But that was the first thing out of his mouth. She didn't ask the question. He just volunteered it right out of the bat. Again, what happened at the time of the vote? What happened when things were being documented? Not what happened here 5.5 years ago, where a bunch of faculty came in and in support of their dean and testified generally under a script. They all did. They were all prepared by Mr. Carroll, and they all had multiple meetings. And if you would notice, most of their testimony was in lockstep. That they all would come up with the same thing, that she said she wouldn't teach analysis, and that when pressed and given opportunity after opportunity, where they were all being nice to her at this job talk, where Mr. Pettis was being such a nice guy and trying to rehabilitate her, she still refused to teach analysis. That is ludicrous. That is, do you think my client, who has taught this class for 3 semesters, has taught in a law school, has written publications, has done all the things that she's done, has worked as a lawyer, looks at a job description and looks at a job announcement, prepares meticulous records to give this talk, and they come in and say, well, even though the class calls for analysis, I'm not going to teach analysis. I'm going to defer that to the full faculty. Nonsense. Use your common sense. Everyone that admitted it agreed that when I showed on Exhibit 136 her outline, and in particular the section about active reading, that active reading is analysis. It's the form of taking the law, taking the facts, synthesizing them, putting an argument together, and saying what you mean. You can write sentences all day, but you can't do active reading all day until you sit down with the document. And you sit down and you read it, you see if you understand it, you start asking questions about it, you start saying, how do I criticize this statute? How do I criticize this holding in light of the facts that I have in this case? And how do I convince a judge or another attorney that my argument makes sense? That's what active reading's about. That's what her questions were about at the bottom. Saying, hey, look, did you ever think of this? What do you say to this? That's what lawyers do every day. Now, Mr. Carroll made a number of promises to you. Remember when he said in opening that Mr. Bezanson was not even at the meeting on January 25th, the faculty vote? Well, not only does Bezanson admit this, but he also admits that somebody was saying that Ms. Wagner was conservative at this meeting. And it's undisputed that Mr. Bezanson was the main opponent to Teresa Wagner's candidacy on this faculty. John Carlson admitted that when he talked to Teresa, that he said to her, Bezanson led the charge. Bezanson was the person who opposed your candidacy. The other main promise that Mr. Carroll did not support was that it was Dean Joseph's burden, not ours, to prove they would have made the same decision regardless of plaintiff's political beliefs. And when he told you that my client refused to teach analysis, well, there may have been some of his witnesses who said that, although none of them could remember the questions ever presented to her exactly. I got admissions from several of the dean's own witnesses, and most glaringly, Professor Ann Eston. Ann Eston said under oath, my client, Teresa Wagner, never used those words, namely that she refused to teach analysis. Now, again, I want to point out that these professors also are very articulate, smart, can present well in front of you and as a jury. But what do they really do with their careers? They write. They write a lot. They write articles every time that they're in session and out of session. And they have resumes that contain all the articles, books, treatises. In fact, you heard a number of them talk about those books, treatises, and everything that they write. Answer this question. Do you honestly believe that had Teresa Wagner given these unbelievable answers on the analysis question, that not one single one of these wordy law professors wouldn't have put that down in writing somewhere? They documented Dawn Anderson's low scores, but she was given second and third chances. They documented Lori Ryan Shear's disaster of a job interview. Remember Mr. Stensvag's long paragraph criticism of her? They documented the disaster that was Matt Williamson's brief time victimizing the students and taxpayers of Iowa. But the only comments to Teresa Wagner's job talk done at the time in which it was given was, great, let's hire her. Do you believe that Sheldon Kurtz, a former dean of the Florida State University College of Law, who's been on the faculty at Iowa since 1974, who's taught these small section classes as a professor, would have written an email within an hour of her job talk presentation that said, great, let's hire her, if she had said the things that the other liberal professors are attributing to her now, namely, I refuse to teach analysis, I defer teaching analysis, I won't teach analysis. Different versions, but the whole gist of it is the defense is from the dean, she bombed this interview. Do you think one of her longtime prolifically writing professors, Sheldon Kurtz, would sit there and write an email to the rest of the faculty appointments committee saying she's great if she had said, I refuse to teach analysis? Common sense says she never said that, and common sense says that Mr. Kurtz would never have delivered that email if she had. Then, the videotape. Where is it? We have a dean who knows that politics is in play here. We know that before the speech, that there were concerns about her politics. It was talked about at the Faculty Appointments Committee meeting in November. It was talked to her by Dean Anderson. It was talked to her at the next day with Mr. Carlson. And if you've got something that stinks of political cronyism, perhaps, wouldn't you, as a reasonable dean, want to diffuse that? Wouldn't you want to preserve the best piece of evidence of what my client said at her job talk so that it supports her argument? So it supports her claim that she absolutely bombed it and that it was a truck wreck, that she said she refused to teach analysis. If I'm a reasonable dean in that situation, I say to myself, boy, That would be a good piece of evidence to save so that I don't have to face any questions about whether politics affected anything here. It didn't get saved, did it? And every one of their witnesses started coming in going, boy, I wish we saved that. Boy, wouldn't that be great if we saved that? Well, they're trying to tell you that this is just, going to support her version of the facts. I submit to you that if we had that videotape right now, you would have watched it. You would have seen how articulate she is. You would have seen how competent she was. And you would have seen how she answered those questions. But it's gone, and we can't do that. What she did do was when she testified in this case, she told you pretty much by memory the sequence of questions asked of her and the answers she gave. And then we get from these liberal profs who come in in a parade saying, well, the gist of it was, what I took away from it was, I believe that she may have said this, but I can't remember for certain. You get to judge the credibility of the witnesses, and you get to judge whether or not my client's good recall of those events is more credible than a parade of professors trying to support a dean who has let politics play a role in this hiring. PowerPoint. I'm going to show you what we believe are her lost earnings at this stage. Wagner made $15,000 as a part-timer in 2007-08 and has proceeded to $29,000 through this year. The full-time position starts at $62,500. When you look at the exhibits, you will see that Mr. Williamson was started at that salary, and so was Dawn Barker Anderson. You will see that through the exhibits, the pay increases for the full-time position increased in those years by that amount. So the differential between her earnings in the positions that she was able to attain at the Writing Center as a research librarian or a research assistant at the library and as basically a person in a law firm helping out a lawyer totaled these amounts versus the $420,000 that she should have earned if she wasn't the subject of political discrimination. That means the amount of wage loss is $277,500. You also have lost retirement benefits. You remember Ms. Anderson and Ms. Wagner do receive health insurance benefits, so we're not asking for that. But the difference is she doesn't receive retirement benefits, and she doesn't receive the other fringe benefits that are set forth in the hiring justification for Ms. Anderson. Therefore, we believe that the annualized loss of fringe benefits is this $13,286 number, and that over the 6-year period it's $79,000. So we'd ask for both of those as the element of damages. Now, the defense will come in and say, well, she didn't mitigate her damages because she didn't get a job teaching or practicing law or doing whatever. Remember, one of their witnesses, and I can't recall right now, but they said that the competition for these positions at the law school increased in 2007, 8, and 9 because the job market was crappy. Everybody knows that. There's been a reduction of the number of jobs available generally in the population and for lawyers in particular over the past 6 years. She didn't have her law license instated because she was practicing or she was working in Washington, D.C. So she needed to bring her CLE credits up. And she did that by 2010. Yet, Mr. Carroll cannot point to you one job in the marketplace that she tried to get, that she was considered for, that was similar in pay and benefits to this LAWR instructor position, that she somehow ignored or turned down. It's not our burden to prove that. It's the dean's. I'd also like to talk to you about emotional distress damages. You saw the effect on my client. She said she somewhat regrets bringing this lawsuit because she burned her bridges. She's lost 13 pounds. She's gone from 105 to 92 pounds. She didn't have that to lose to begin with. She has no sleep. She worries about how her lack of income can affect how she provides for her 4 kids and helps her husband do that too. We would suggest a fair range for her emotional stress damages to be within a range of 50 to 100,000. You might think that's too much. You might think that's too little. I'm just making a suggestion to you, but we believe that the evidence does prove that there are emotional distress as the result of the discrimination that she faces and the equal protection that she was not given. A motivating factor. You will be instructed what I had to prove on behalf of Ms. Wagner in this case was that politics were a motivating factor, not the motivating factor. There can be more than one motivating factor, but as long as I prove that politics was in the mix, you'll see that we've carried our burden of proof. However anybody voted, nobody is ever stupid enough to say anything about that, namely Teresa Wagner's politics, in a faculty meeting. That's what Mr. Bezanson said. But then he said, at some point I picked up someone was saying she was conservative. And then I asked him another question, and he answered it this way. Now, you mentioned earlier that Wagner's politics may have been discussed at the time in which a decision was made whether to offer her a position or not. Answer, it may have come up. Yes. Well, at least he's being honest about the whole process as opposed to everybody else denying that it came up or not remembering that it came up or so forth. Carolyn Sheeran, at the time of her job talk, someone had mentioned to me that she was pro-life because I guess something on her resume had mentioned that she was pro-life. So despite the fact that they paraded up a number of witnesses in this case to say nobody talked about her politics at the job talk, Ms. Sheeran's own statements in direct examination are to the contrary. Now, you may not agree with her pro-choice position, and you may agree that a woman has the right to choose consistent with the Roe v. Wade decision. We're not asking you to agree with her. We're just asking you to make sure that that position, that political position that she takes, doesn't affect her ability to get a job. Then we have, again, the Carlson email. Frankly, one thing that worries me is that some people may be so opposed to Teresa in serving in any role, at least, is because they so despise her politics, and especially her activism about it. So they know not only that her politics are there, but that she's active. She supports her arguments. The faculty knew that Wagner's politics were pro-life because they've admitted it. Dean Jones admitted it in testimony, Eric Anderson, John Carlson, Peggy Smith, Carolyn Sheeran, and Adrian Wing. Every one of those witnesses said that before the job talk, they knew her politics were conservative. Remember the testimony of Mr. Anderson. Everybody knew your politics. It was right there on your resume. And then, again, Ms. Sheeran, someone had mentioned to me that she was pro-life. I guess something on her resume had mentioned she was pro-life. Did the evidence show what Ms. Jones's political leanings are? The law faculty at the university is viewed as being liberal. Mr. O'Seal told you that they're liberal. Only 1 out of 50 professors is a registered Republican. Wagner's a Republican, conservative, opposes Roe v. Wade, anti-euthanasia, supports traditional marriage, and they refuse to hire her. Faculty there, and including Dean Jones, are liberal Democrats. They have Professor Bezanson drafted Roe v. Wade in conjunction with Justice Blackmun. Professor Kurtz wrote in support of euthanasia. They have hired 2 female faculties 20 years ago as the first openly gay couple on a faculty, and they hired Matt Williamson, who's an off-the-charts liberal and hates Republicans. Did you inform Miss Teresa that it was Bezanson who was the main professor to speak out against her? Yes. So the second point is that there is very clear contrast between Teresa Wagner and Dean Jones and virtually every member of her faculty. She was qualified. She actually taught this same class, taught advanced legal research, writing, and analysis at George Mason University for 3 semesters, or over 2 years of schooling. Her professional experience is reflected on her resume: teaching, writing, working as a lawyer. The appointment committee deemed her not only qualified, but one of the 4 most highly qualified out of a field of 50 applicants. In fact, Mr. Janis said she was very well received by the committee, and then would be talking to her again about the next stage of the process. So then again, he tells her they're very enthusiastic about her candidacy and tells her when the interview is going to be. Then Peggy Smith, who you heard from earlier today, says that she spoke with Helen Aver, an associate professor of law at Catholic U. She thinks Teresa would be very good at the job. She is intensely hardworking and incredibly demanding of herself. She likes to work. She really enjoyed being a lawyer. She believes that Teresa would be very enthusiastic to translate her energy and passion for the law to students. That's what they're hearing before they go into this job talk. And now we're hearing that she's great. We've been talking to her and she's awesome. She's friendly, approachable, nice, and smart. Would they hire Matt Williamson? Somebody who skips classes, doesn't do the assignments, gets universal discredit from his students, and still is yet allowed to continue to teach them, despite Mr. Bonfield's statements that we shouldn't victimize our students with bad instructors. Sheldon Kurtz, 2:59 p.m. Great, let's hire her. Ted Potter, a co-worker in the library. She's enthusiastic about working with the law students to help them become good legal writers. She has teaching and writing experience and is familiar with the law school. She has made good comments about how she would teach LAWR. Where's the comments from all the peanut gallery of the professors that are liberal here that says she made terrible comments about how she would teach LAWR? Well, she didn't, because it didn't happen. And what really happened was they were talking about her politics at the faculty vote. No negative comments ever about this woman's candidacy until she decided to sue him for political discrimination. Were you in favor of offering Ms. Wagner a full-time position? Yes, I was. Did you support her being hired as a full-time LAWR? Yes. She's qualified. The only contemporaneous reviews were very positive. Both associate deans, who you would think would be well familiar with the requirements of this position, both fully supported her candidacy. So we get an off-the-charts liberal in this position, despite the fact that there were 2 full-time openings. We have direct and circumstantial proof that this was because of Teresa's politics. Dean Carlson warned Teresa prior to her interview not to tell the faculty of the fact that she had interviewed for a tenure-track law school teaching position at Ave Maria School of Law, a conservative law school. His spin on it now is, well, that's just tacky to say that you got offered a job somewhere else. Well, contemporaneously, Miss Wagner saw his reaction when he found out that it was Ave Maria, a conservative law school, and that his face just kind of dropped and he was shocked that she would have that type of offer. Dean Jones admits that prior to the interview, Anderson informed her that Teresa hoped that the faculty would not hold her political views against hiring her, and Anderson admitted he didn't know if they would or not. But then he said, well, we just don't want you to teach politics in the classroom or anything, and let your political views be made known. What about Pat Kane, the openly gay liberal professor, who said in a blasted email to the entire law school with respect to same-sex marriage, we won in California. Please pass this on to all the faculty and staff. She let her politics pervade the school and go into the classroom, and yet Teresa has to conceal her politics. And then the email comes out. I don't understand the significance of the faculty's unwillingness to vote on proving Teresa as an adjunct. It seemed that there might be an undercurrent of opposition to even that. If you remember, the only person who said that we have to gather a group of candidates later was the dean. She should have been given that adjunct position on January 25th. And that Carlson is baffled because she wasn't. Because when you recommend somebody for an adjunct as a faculty in whole in the faculty appointments committee, it's usually rubber stamped. Remember? Not one person could recall ever having a universal recommendation from the faculty appointments committee that somebody serve as an adjunct and then have that rejected. That's the first time ever it happened. Unusual circumstance, unusual situation. Doesn't the dean have to come in and police that, as she said she would if there were unusual circumstances? I submit yes. And she ignored it because she knew that liberalism was well alive at the University of Iowa College of Law. Remember I asked her in rebuttal today about, would you stop an illegal action of your faculty, basically? Namely, if they recommended to you that somebody not get hired because of illegal conduct. She kind of hemmed and hawed with me and said, well, that didn't happen here. And I asked them that question about a disabled person who was a wheelchair bound, and she attends the job talk and hears that the faculty is rejecting that candidate, not because of qualifications, but because they don't want to be around somebody in a wheelchair who can't talk and so forth normally. She said, well, yeah, that's an unusual circumstance, and I have to probably step in and do something about that. What's the difference here? What's the difference when they're sitting around despising her politics and her activism for it, that the dean simply can say, rubber stamp. I'm a $300,000 a year rubber stamp. I don't have to use any independent exercise of my judgment in this case. Now, the dean is telling you she shouldn't have gotten the adjunct position, but yet she invited her to apply for it. The dean wants you to do that. Remember this email from Mr. Janis? During our meeting, a number of faculty expressed hope that you'd be willing to be considered for a possible adjunct appointment. Dean Jones has asked me to follow up with you to inquire whether, indeed, that would be something that might be of interest to you. Do you think this dean of this law school would have asked Mark Janis to follow up with Teresa Wagner if she, in her heart, believed that this was a bomb of an interview, that she refused to teach analysis, and that therefore she was totally disqualified from ever being considered for this position. Contemporaneous documentation is contrary to the position she's taking in this court. The ad said, prior successful law school teaching experience in these areas is strongly preferred. What experience did Matt Williamson have? John Carlson, I would prefer more mature and more experienced instructors as a general proposition. Carlson candidly admitted Miss Wagner was both more mature and more experienced than Williamson. He hadn't practiced as a lawyer. His only teaching experience was one half semester in the fall of 2006 as an adjunct. He never published anything of legal nature. Teresa Wagner had teaching experience, had publication and authorship of legal reviews and articles, and including an amicus curiae brief to the United States Supreme Court, had experience in the private sector. You compare those, and you have to question yourself as to common sense again. What was this faculty thinking about when they're recommending to Dean Jones that he be offered the job and she doesn't? Even though they still have two positions. No one could remember the exact questions and answers that were presented in this case to my client in the job talk. Both John Carlson and Ann Eston testified under oath that Teresa Wagner never said, I refuse to teach analysis, despite the dean's position. They said the testimony went all over the place on this. She refused to teach, that was not part of her job, that she would defer to the doctrinal professors, that she did not understand what analysis meant. This was Dean Jones's burden to prove, not my client's. That changing testimony goes to show that it's not believable, that it is pretextual, that they're making this up to try to defend a decision that was made by the dean to allow politics to play a role here. And the last item I want to list for you as plaintiff's proof for that her politics played a part is the fact that it turns out Professor Carlson was right. There was an undercurrent of opposition to Miss Wagner in any role. Despite applying and despite full-time openings in both 2008 and 2009, Teresa Wagner was never selected for an opening after this. She's passed over for the adjunct positions 2 months later. Dawn Anderson says that she didn't get to be a candidate for that until April or early May, totally contrary to what the dean said. And she got to improve. She got mentors. Remember, Pettis and Sheeran mentored her after she had to withdraw her candidacy because she had a 2.11 score in the first semester. And she improved for one semester, but then again, her 2.25 score in the fall of 2007 wasn't held against her when she came up for the full-time position in January 2009, despite the fact that both Mr. Kurtz and Mr. Bazanzin said that 2 or more bad reviews by students in a semester on grading, meaning that they were in the low 2s, should be an automatic disqualification of that candidate from consideration by this faculty for a full-time position. We believe that that proves our element of equal protection. My client was a conservative female who got one chance at one interview. Dawn Anderson, a liberal Democrat, gets multiple chances to improve herself before she can go in and be a candidate. Also, Lori Wren Shear, another candidate who got the spring of 2008 job, was allowed to be an adjunct, was allowed to get her first experience as a teacher, and yet, despite universal panning of her by strongly worded professors who didn't hesitate to use their email system to tell us what they really thought of this candidate, despite the fact that she bombed her interview and that Mr. Stensvag said she would be a disaster, the dean accepts the offer and lets her become a full-time instructor, despite the fact that there were 2 openings at that time, too. Because remember, at that time, Mr. Williamson was bombing out himself and was going to leave, so they had 2 positions to fill, yet they won't even consider my client. That is a denial of equal protection. I'll let Mr. Carroll now come and talk to you about what he believes the facts show in this case and his argument, and I'll talk to you later briefly. Thank you.
Ladies and gentlemen, you've been sitting over an hour. You want to take a moment to stretch?
Versus Carolyn Jones. Does not say the University of Iowa. It does not say any other professor that they've talked about that could have, may have, did talk about her politics and use it impermissibly. You have one named defendant in this case, and it's Dean Jones. And that's who you have to think about factually and with the instructions the court gave you in this case. And when you think about everything we've talked about for the last week in this case, contemplate the question, what did Dean Jones do wrong in this case? Every time you must focus on the instructions and the facts, but what did Dean Jones do wrong? We talked in detail about the hiring process in Iowa because it's important in the law school faculty. And it may, we get to use our common sense experiences. We've all applied for jobs. We've had one-on-one interviews. Perhaps you've had committees that interview you. But in the process for the University of Iowa, which has been the process for many, many, many years, is that applicants apply through a variety of ways. There's an appointments committee made up of faculty. They screen the job applicants. And all that means is the committee, who are peers with the entire faculty, are saying, we think these candidates should proceed in the process. And that's what we always have to do. There were approximately 50 applicants, and we had to hone that down. And we did. And we honed it down to 5. But 2 withdrew. So there were only 3 that were screened through, as we say. Now ask yourself this question. If we so despise Ms. Wagner's politics, and we are such a liberal, biased faculty at the University of Iowa College of Law, why screen her through? The best time to stop somebody, if you're going to do it, and they're claiming that's our plan all along, is stop her when she's one of the 50 and put her in a mix with 50 other people. Why even give her the chance to go to the faculty if you're so against her? And the answer is, they weren't so against her. She was qualified to give the job talk. And she did that with 2 other candidates. And it's interesting that you recall in this case, a candidate, Estelina Dalit, was screened through. She didn't get a job offer. She didn't have a good job talk because the faculty can see a resume. They can see where she's been. They clearly saw she says she taught at George Mason. We accepted that at face value. We, in fact, tried to get her evaluations to review those. We can see that. So why have a job talk if the paper trail's all you need? Because it is the most important part of the interview process. You have got to convince your colleagues in the College of Law that you can do the job as they see it. And it's critical to those faculty members to listen to. And they do listen. You'll see in one of the exhibits, there were 25 people that made the job talk, which is really pretty good considering how busy the faculty is. and they listened to her. They were polite, they were considerate, and they asked thoughtful questions of Ms. Wagner. The hiring process also has demonstrated for at least 50 years at the University of Iowa College of Law, the faculty does the hiring recommendations. And the reason they do that is because, particularly with what Professor Bonfield testified to, the dean, even though she's an accomplished scholar in her own right, she is now and was in an administrative role. She had budget problems. She had classroom problems. She had all kinds of scheduling issues that you administratively have to take care of on a daily basis. But the faculty is engaged in the scholarship at Iowa on a day-to-day basis. So they judge who they think will be a good faculty member on those grounds. And there's reasons for that, not just who they judge will be good. It's also, and remember there's testimony that there's a 2/3 vote required, a positive 2/3 vote required. And that's so we invest in these candidates. Some move from the East, and you heard these witnesses, they lived on the East Coast and they moved to Iowa City. We invest in these candidates, and when we have them walking in our door, we want them to be supported by their future colleagues. So if you have a 50-50 vote, or 51-49, you're walking in the door with 49% of the people who don't think you should work at Iowa. So the 2/3 rule is a good idea. It gets faculty to be supported and that the faculty thinks they're qualified to teach at the University of Iowa. And one of the instructions, and as the court told you, you must follow the instructions, is instruction number 9, which is the defendant's business judgment. And it, in essence, says you can't substitute your judgment for the only defendant in this case, Dean Jones, because you think the decision was harsh or unreasonable. So this isn't, well, that wasn't fair, or I really liked Ms. Wagner on the stand. You have to find that Dean Jones violated Ms. Wagner's constitutional rights under this record. Now, we do know from the record that 3 finalists gave job talks: Matt Williamson, Teresa Wagner, and Estelina Dowlett. Ms. Dowlett didn't make it out of that screening process. Matt Williamson did. And there were emails similar to the emails in support of Ms. Wagner that supported Mr. Williamson. And let's talk about Mr. Williamson in a little more detail. He didn't turn out well, okay? Nobody's saying that he did. But we don't know what's going to happen when we hire people. We hope they'll turn out well. We hope everything will go as planned, but it doesn't always go as planned. And that is life in and of itself, and that is certainly employers' decision-making. Not every employee you've had as a coworker has turned out well, I suspect. I've had many, many jobs in my life before I became a lawyer, and that's just the reality. And Mr. Williams didn't turn out well, but on paper, he seemed like he would, and he had this very same support that Ms. Wagner had in those emails. And notice there are at least 1, perhaps 2 emails that are written by the very same professors that said, hire Ms. Wagner, and they also said, hire Mr. Williamson. And so that was the same kind of support from the people that Ms. Wagner wants to rely on in this case. And the other thing that's interesting in this case is the distinction that they want to make as they're moving along. Shelley Kurtz, great, let's hire her. That email's in the record. That's what he thought. Part of his deposition transcript was read into the record. But at the same time, you just saw a comparison screen that had Professor Kurtz in favor of euthanasia, and she's against euthanasia. So in that corner, Mr. Kurtz is bad, liberal, Democrat. But over here, great, let's hire her. Love that email, I'm going to use it. So what we're doing is we're picking and choosing how to pick apart this faculty and what they did in this case. Let's look in detail to what the professors said on their stand. Now, I think it's interesting that professors come in here almost 6 years later and don't all tell the same story. Mr. Fiewiger asked virtually every one of them, did you meet with me, Ms. Lucas, or Ms. Esbrook? Yes, I did. The meetings weren't very long. And if I was scripting these people, I did a horrible job. They said, this is what I remember. And so when you have variations of that recollection, that's the most honest thing there is. You're not even going to see the same event the same. You may not remember it the same, or you're just going, no, this is what happened. So when we go through this testimony in detail, Professor Bonfield, you have to remember that man when he testified. He testified, Ms. Wagner's presentation focused exclusively on writing technique. Her presentation sounded like she wanted to be in the writing center. And Professor Bonfield knows full well what's in the writing center. He also testified, Ms. Wagner said that legal analysis is in the purview of the doctrinal professors. On follow-up questioning, she kept coming back to writing and research. Next, he said, Ms. Wagner's answers disturbed me because writing without analysis is meaningless. Those were his words. After the job talk, walked out thinking she's up for the wrong job. She wanted the job in the writing center, not this job. And then remember, she got an F on her job talk. She flunked it. He witnessed that job talk. And this is his recollection of what happened. Now, it's fine for Ms. Wagner to take the stand in this courtroom and say, I went off my outline and I said all this, and this is legal analysis. But the problem is the people that are the judges of what legal analysis is, not what occurred. You're the judge of what occurred, but of what legal analysis is, they were in that room. Professor Bonfield has taught for 50 years. He understands legal analysis. He understands the words Ms. Wagner used in this courtroom. But what he's saying is, it didn't happen at that job talk. And think about the accuracy of these statements by these professors in the sense of, we were ready to hire her. All she had to do was have a good job talk. There were 2 openings. And Estina Dalit had already gone and was not going to be hired. All she had to do was have a good job talk. And that's what most of them are saying. They just have a good job talk, and it's probably going to happen. Then Professor and Associate Dean Todd Pettis testified that, in his opinion, Ms. Wagner didn't understand legal analysis. And he followed up with a question to Ms. Wagner. That's why he asked, what is the A in LAWR for? Well, it stood out to him. Remember, he was on one of the forming committees, and this was a big change at the University of Iowa. We were basically taking where faculty taught legal analysis in small section and creating a whole new class system of teaching. And analysis was always the sticking point. We have to make sure the instructors teach analysis. And Professor Pettis was concerned about the answer and asked the question. Now, there's been argument that all of the professors that took the stand are making this up. And why? Because we did discriminate against Ms. Wagner. Now here we are in a federal courtroom, and we've got to come up with an answer. But the fact of the matter is, their testimony is credible and believable that she didn't cover this. Why would he ask this question if she had talked about analysis in any manner? And the answer is she didn't talk about analysis. And we don't really know why. Some of the professors believe she didn't understand legal analysis. Professor Bonfield thought, she's got the wrong job. Others may have thought, I just don't know why she did what she did, but it happened. It's remarkable to all of these professors. And remember the professors that were in favor of Ms. Wagner? John Carlson, Eric Anderson. They said she didn't answer the questions correctly also. Her best allies in this case did not square with her testimony. But why were they still in support with her? Because they thought, as one said, we could educate her, we could rehabilitate her, we could sit her down. But the other professors didn't see it that way. And they had the right to not see it that way. I think it's the most telling that the people that supported her then, and perhaps today, said she didn't do well at that job talk. The thing we needed the most. Professor Herbert Hovenkamp testified. Ms. Wagner said that legal analysis should be taught by the regular faculty, not the LAWR instructors. That was his testimony. That is, if it's not the word, that is the refusal to teach legal analysis. And how does he describe it? This was a startling answer. And so when we say, how can you possibly remember this almost 6 years later? One thing is, it was so remarkable. They're sitting in that room, they have the job description, they have the job ad, they all teach legal analysis, and that's what she says? So that's why it's so remarkable. And so when they don't remember the exact question, the reason why they remember the answer is because it stood out. It stopped the room in its tracks. It was described by the dean actually as a truck wreck. Other people described it as the air going out of the room. It was so startling to everybody. And the follow-up questions, and one witness testified, I'm not sure why we kept asking questions. We were nicer to her than most people were nice to. Once they give an answer like that, it's over. They were nice to her. And they asked her 2 more questions about analysis. And she, as one witness said, stuck to her guns. Professor Hovenkamp believed that she was not capable of teaching legal analysis. So that's his take on her answer. But it doesn't change the fact she gave that answer in that job talk. LAWR instructor Carolyn Jones testified that she did not understand the job I do or want to do it, or she didn't want to do it. Here's one of the individuals that was in the room that's actually one of the instructors. And she even said that I was absolutely floored by her answer. And the reason she was floored was because that's what she was teaching. And you remember that Mr. Fiewiger said that there was this hostility between the two. But the fact of the matter is, she said she didn't like the answer because it came off like that she only teaches grammar. But no, she's teaching analysis in that position. And so to her, it stood out because it was missing the key component of the job. And remember the testimony about how we get to the acronym? Now, they keep denying to me that this LAWR doesn't mean lawyer or stand for lawyer in part. But the fact of the matter is, analysis came second. Legal's there anyway. We're not teaching engineering, so it's going to be an L. And then analysis comes second because it is so important to everybody. And here's a person that was teaching that job. This would have been her first year. The program started the fall of 2006. And this is the answer we're getting. And so, again, it was remarkable to her. And if you ask yourself why this is remarkable to people, everybody has a job that there could be 2 or 3 things you simply have to do, and it doesn't matter what your job is. But, for example, if you drive a truck for an employer and you have to have a DOT license, and you don't have one and you won't get one, you're not going to get the job. There's just no 2 ways around it. So it's so remarkable that she said that. She took the key component of the job, and she said, I'm not going to do that, or it's somebody else's job. That's the essence of what she said. And that is remarkable. to these people. Clinical professor and associate dean Linda McGuire took the stand, and Ms. Wagner's presentation was about technical writing, so questions about analysis were not unexpected. Now that's valuable because Ms. Wagner claims that she did talk about analysis. You know, the problem with having an outline is, it doesn't mean I said it. I have an outline. I may not say every word on this outline. I may forget. I may move on. And for her to say, because I had it on my outline, I said it, isn't enough. And that's why Professor McGuire's testimony that the questions were not unexpected is because her job talk, the formal presentation, was so lacking in teaching of analysis, those questions came up. If it was so thorough and good, as Ms. Wagner says, the questions probably would have been along the lines of more, why do you want to teach at Iowa at all? Why do you want to go full-time at Iowa? Are you, things like that. They weren't, because these questions were not unexpected. Now, Professor McGuire testified. She said she wouldn't teach legal analysis. I said in the opening statement that her answers to some were disqualifying, and that she said she wouldn't teach legal analysis. Here is one of the witnesses that used those exact words. They all get to that essence, but these are the exact words. And remember, Professor Bonfield said she got an F. That F was because she said she wouldn't teach legal analysis to the students at Iowa. The next professor testified, Ms. Wagner said legal analysis is not part of the job without a doubt. And then she said she shot herself in the foot. That's saying you're not going to do it. Our witnesses are saying she said she's not going to do it. Professor Steve Burton testified, Ms. Wagner said that legal analysis is the province of the doctrinal faculty, saying, I'm not going to do it. It's for you, Professor Burton, Professor Bonfield, Professor Hogenkamp. It's up to you to do that. He also testified she was stuck on her refusal to teach legal analysis. What they're attempting for you to conclude is that Dean Jones, the only named defendant in this case, brought in these faculty members and they didn't tell the truth under oath. And what's their motivation? They work at Iowa. They've been there a long, long time, and they're not going anywhere probably, and they're certainly not in trouble for coming into this courtroom. You would have to conclude that these specific words they used, without the exact words in all cases, that they are not telling the truth to you. And that's an awful lot of people for me and Ms. Jones to have corralled together. Not one of these witnesses was subpoenaed in this case by my party. They didn't have to be here under that scenario. They came into court and told you what they recall about what happened, and they all have told you that she was most likely to get that job if her job talk had gone okay. Now, this is a very interesting witness, the Writing Resource Center Director, Nancy Jones. That Nancy Jones is Ms. Wagner's current boss. And throughout this entire process, Ms. Jones has continually offered job contracts to Ms. Wagner in the Writing Center. Everybody agrees she does a wonderful job there. So despite this animosity towards Ms. Wagner by Dean Jones, we still employ her to this day. We've increased her time from quarter time to half time. We've put her on our health benefits plan. But if our plan is to undermine her and not tell the truth about her, why didn't we get her out of our building a long time ago? Those were year-to-year contracts. There was no reason to have to renew those. But we have. There is no animosity towards Ms. Wagner in that sense. And this is her testimony, Ms. Jones's testimony, is so interesting because she so clearly likes Ms. Wagner to this day. Remember her testimony that she went and saw her when she was in a play in the local community theater in Iowa City. And she didn't have to do that. I mean, go to work. Hi, Ms. Wagner, how are you today? I mean, she clearly liked her and likes her to this day. And remember what she said? I wanted to crawl under the table. I was embarrassed for her. And I find that answer so telling because we've probably all been in that situation where something just happened and you're like, oh man. And it doesn't matter if it's your kid just did it, your spouse just did it, anybody or somebody you know, and you're like, oh, that's exactly what Ms. Jones testified to. Now, if Dean Jones has got the conspiracy theory going, why would Ms. Wagner's friends say this is what happened? Now, there were questions about the budget, and you're at the mercy of Dean Jones. Well, I don't think so. She's still a University of Iowa employee, and it's the University of Iowa's budget. So it makes no sense for Ms. Jones to say what she said, except it's true. And when you take all the differing but closely aligned stories, that rings the bell of truth. And then she said, I wanted her to succeed. And she was so glad when Professor Pettis asked her another question. And remember how Ms. Jones described it as, oh, good, Professor Pettis is a nice man. He'll ask the question in a nice manner, in the right way, to get her to answer the question correctly. And maybe that'll save it. But she didn't. And Ms. Jones told you that. And I will tell you this, if Ms. Jones later told Ms. Wagner that she gave a good presentation, that may very well have happened, but you saw her on the stand. She's a nice, likable, civil person. And people in Iowa say things like that. Good job when you're walking away shaking your head. You know, what just happened? So if in fact she was supportive of Ms. Wagner, it's entirely explainable. Because Ms. Jones took that witness stand, took the oath, and said, I was embarrassed for her. Well, that isn't a good job, but she was being nice. Professor Adrian Wing testified that it wasn't clear if Ms. Wagner understood legal analysis. This is a variation. She did not testify that she refused to teach it. So this is a person's recollection of what is occurring, but she's saying, as far as Professor Wing was concerned, she didn't seem to understand it. And other professors were concerned about that. You know, the relying on the outline to say active reading is analysis and its content. The professor said, but that's not enough. You can say those words. This is so critical to what we do at the University of Iowa, particularly the first year, that Professor Wing walked away with the conclusion that she didn't understand legal analysis. And we can't have that. We just can't have that. Now, Professor Peggy Smith, similar testimony, I'll go through it, but if these witnesses last week are at the beck and call of Dean Jones, Peggy Smith isn't. She works at Washington University in St. Louis. You heard her credentials. She doesn't have a dog in this hunt. And she testified that at the job talk, Ms. Wagner said she did not think analysis was part of the job. Again. Now, the dinner, what adds value to Professor Smith's testimony is, under the protocol, we take all the candidates out to dinner. And Ms. Wagner accurately remembered who was at dinner with her. Now, this is a social setting. It's a chance to relax. A lot of times if candidates are from out of town, we sell the city of Iowa City to them and the University of Iowa. Didn't have that with Ms. Wagner, of course. But Professor Smith clearly testified that she raised the question about analysis. And why? Professor Smith said she wanted to give her one more opportunity. And what would be the opportunity except to clean up the answer at the job talk? Ms. Smith asked her about it. She gave the same response. And then Ms. Smith testified. The response she gave settled the deal as far as her vote was. And I asked her, and settled the deal meant I am not going to support her for the LAWR position. So we not only have a job talk where it was brought up, we have a dinner where even if you gave Ms. Wagner the benefit of the doubt that she was nervous at the job talk, which I don't think she was. She seems pretty polished to me, and we know she was an actress. Even if you give her that benefit of the doubt, in that social setting, she still said she wouldn't do it. And Professor Smith remembers that. Professor Christina Bahanan testified, the job talk itself, good ideas about teaching writing as writing, but nothing about analysis. Then there was, Professor Bahanan remembers the questions at the job talk, not the specific words, but remembers the questions being asked. And Ms. Wagner answered, according to Professor Bahanan, it's not the job of the LAWR professor to teach analysis. That is akin to saying I'm not going to do it. Again, this is so remarkable. You heard from Professor Cox this morning, and Professor Cox brings an interesting perspective to this courtroom because she remembers Ms. Wagner as a student at Iowa. Only a couple professors did. I believe John Carlson and Eric Anderson did. But Professor Cox remembers her because Professor Cox had a radio show, a local radio station in Iowa City, and had Ms. Wagner on as someone who was of a conservative voice. And she testified today that she did a wonderful job. And she had no ill will to her political views or affiliations. I mean, she told you what her political ideology is in part, how she's registered to vote. But the fact of the matter is, Professor Cox said, Ms. Wagner expressly disavowed the intent to do the most important part of the job, which was legal analysis. So we have somebody that was supportive of her, clearly liked her, and still said, but that's the answer we got. Professor Ann Eston indicated that Ms. Wagner said writing is more important than legal analysis. Now, and that's her recollection would have occurred. It doesn't seem to be as harsh as some of the other recollections, but I submit that adds value. That 5.5 years later, they're not going to be perfect recollections, and I submit if they are, there's something wrong. But Professor Eston said it was very awkward and uncomfortable in the room after she said that. And so, again, an experienced professor having the same take from those answers. Professor Eric Anderson testified with respect to the job talk. Ms. Wagner did not understand that legal analysis is part of the job. This was surprising. Now remember, this is her ally. This was surprising given the name of the job. Thought analysis went without saying. This was a huge misstep. And this is her ally. He supported her on the committee. He's one of the committee members that screened her out. He supported her after the job talk. He supported her as an adjunct. But he says she did exactly what everybody else said she did. And the reason why that's so critical is he was a supporter of hers from the get-go. But he didn't say they couldn't have walked out of that job talk thinking, no way. I mean, nobody has taken the stand in support of Ms. Wagner and said those faculty members couldn't possibly have thought that about the job talk and or concluded that she was not qualified anymore. They didn't say that. Her own supporters admit this job talk went horrible. Dean Jones testified that she was at the job talk. And let's clear up about all these voting things and voting rights. First and foremost, Dean Jones does not vote at the faculty meeting. So she did not vote there. But she does go to the job talks because it is a potential colleague. And I don't think it would be very good protocol to be the dean of the law school and have a prospective professor come in and you don't even go to my job talk. Of course she's going to be at those job talks. And Dean Jones said, Ms. Wagner said she would not teach legal analysis. On follow-up questioning, she still said she would not do that part of the job. And she said it was like a truck wreck. And she used those words because of what was happening and what she was witnessing. Now, Professor O'Seal testified, but let's recap what he testified to. He did not attend the job talk. He doesn't attend faculty meetings. He said, I've distanced myself greatly from the entire process. He also testified that's because the law school is so liberal or something else. But the fact of the matter is, he does not engage with his colleagues for whatever reason. He has no facts to what occurred in that job talk or the faculty vote. And he wasn't even going to go. He doesn't go anymore. His high recommendation of Ms. Wagner was as an editor, not as a teacher, not as a professor at Iowa, not whether she could handle legal analysis. And he certainly didn't go to the job talk, so he couldn't address that issue. You've heard in detail Ms. Wagner's version of what she said at the job talk. You're going to have to decide what happened, and that's what jurors have to do. You are the decider of fact. The judge and the legislature are the giver of the laws. And so you must decide what happened in comparison to what you heard in this case. And remember, the key component is this is discrimination only against Dean Jones. I will say that you may find that some faculty members did things that maybe you do not approve of, or possibly did things you do not approve of, but you have to focus on Dean Jones. And you have to ask, what did she do? And what did she do wrong? You know, you are being given instructions on a violation of the United States Constitution. This isn't a car accident. I don't mean to minimize the severity of car accidents. I mean, you are not looking at a fact pattern of who ran the red light. You are looking at whether Dean Jones, and only Dean Jones, violated Ms. Wagner's constitutional rights. And the knowledge of politics in this case, because it has to be known, you know, gender and race discrimination is against the law. When you interview people in person, you can figure that out real quick. Politics is much different. It is improper to ask the question in the first place. When we have this, we're nothing but a blazing liberal faculty at the University of Iowa. Well, you can't ask that question. Whether they're of like mind over the course of time or research and scholarship, but the fact of the matter is, you don't sit down to anybody and say, are you voting for President Obama in 2 weeks? Or have you already voted for President Obama? You don't do that. And so how do we get at her politics? Well, we get at it here by her. We have no animus to dig at it. And we get it, you can read it from her resume, but you'd have to have read the resume. And some faculty members said, I didn't read it before the job talk. I wanted to go to the job talk. You could have got it when she was a student, but there were only 3 professors out of the 25 at the meeting that even remembered her. And you'd have to prove that Dean Jones knew of her politics and somehow acted upon it. And what did she know, potentially, about Ms. Wagner's politics? Well, she knew that Ms. Wagner on her own came to Dean Anderson and said, will they take my politics against me? She put it on the table. So when Eric Anderson later told the appointments committee about that question that Professor Smith testified to this morning, it's because Ms. Wagner brought it up and Eric Anderson did the right thing and took it to the committee and said, hey, I got this inquiry. So she put her politics on the table. Then her politics are, you can glean them from her resume, but of course we got to look at the resume and the conversations that, well, maybe somebody said she may be conservative. Well, Ms. Wagner brought that up and brought it up with an appointments committee member. Any conversation along those lines would be appropriate. Now let's look at the lawyer hires that are being challenged. Matt Williamson had successful adjunct experience and good qualifications on paper, so he was moved forward. Ryan Schweer, who later was hired in these cycles, had an excellent and outstanding academic record, just stunning at the University of Iowa, the top of her class. It made sense to hire her. She's still on her faculty. You heard testimony that's turned out well. So we're 1 for 1. Matt Williamson didn't turn out well, but Ryan Schweer has. You heard about Dawn Anderson and all the valuations on her. That poor woman, I mean, she wasn't on trial. Dean Jones was on trial. Yeah, she didn't have good evaluations. She admits it. You remember the deposition testimony that was read in? She cried to the then retired dean about the evaluations. She took them seriously and she tried to improve, and she did over the course of time. And then there was criticism that, well, we mentored her, but we wouldn't mentor Miss Wagner. But that's the exact opposite of what happened. Professor Anderson went to people and said, how can I improve? How can I get better at this? Went to people for the full-time job. What is it that I can do? That's up to the job applicant. Just like anything else, you got to at least show some initiative. And that's what Professor Anderson did. At the same time, what did Miss Wagner do? Did she pursue, what did I do wrong? What happened in that job talk? No, she immediately went to the defensive point of view. I didn't do anything wrong. I don't need to get better. Why didn't she sit down with her ally, Dean Anderson, and say, what happened? But she didn't. Oh, did I really mess up those questions that poorly? What can I now do? And that never happened. When we look at the adjunct positions in this case, first thing, you have to be very careful factually. The very first job she applied for was the full-time LAWR position. She did not get screened through for that. After the job talk, she was no longer considered a viable candidate. The adjunct that she's challenging us on was for the very next term to teach, the fall where she didn't get the full-time job. Okay? Now, it's true the committee recommended her for hire, but you heard testimony that the committee is just our peers, and it still has to go to the faculty. What made this different historically is adjuncts don't give job talks. They had just walked out of a job talk that they universally viewed as an absolute failure. And they had the right to say, we're not willing to hire her. And that's what happened on the adjunct position. And it makes complete sense. The appointments committee did say, let's move her forward to the faculty, but they knew there'd be a vote. And she didn't come out of that faculty vote again. And remember, the record is clear that Dean Jones, historically, at the College of Law, and with the other deans, did not have the authority to hire somebody that wasn't recommended. What you do have in the evidence is one example. 1975, was that 37 and a half years ago? One time at the University of Iowa, the dean didn't hire who the faculty recommended. The dean, however, did not go out on the street and pull somebody else. In this case, Ms. Wagner did not get a recommendation whatsoever. The same fact pattern would have been Ms. Wagner's recommended, and Dean Jones, under the history, could have said, no, that only happened once, but that isn't what happened here. Her name never gets out of committee for the dean to act upon. So this goes back to what did Dean Jones do wrong? What did she do in this case? And when you don't have her forwarded, then what? Now they're claiming, because of the conversation with Professor Anderson and Professor Carlson, that she should have done more. But what? She talked with Professor Carlson the day she got the email and said, well, what do you have? I remember Dean Jones described how she's actually on the second floor of the building, but the faculty are on the fourth floor. That's where they have lunch. That's where their offices are. That's where they go after classes. Okay. So she asked, so what do you have? Is there something on the fourth floor I don't know about? Well, that's when, I heard somebody talk about this. Or, I was walking down the hall and somebody said, oh, she's just a right to life. Or, we can't have that. But Professor Carlson had nothing for the dean to act on. And that's what she did. She went to the person who sent the email in a timely manner and asked, what is this? But then there wasn't anything. Now, what did she also have at the very same time? She had objective evidence on why Ms. Wagner wasn't recommended, because of the job talk. So she had her own evidence to say, there's a perfectly good reason why she wasn't recommended, and I don't have any facts to go look into. No, you're not giving me anything, Professor Carlson. I read your email, and I took it seriously, but you're not giving me anything to look into. The comments that Professor Carlson, her ally, obviously had some discriminatory basis because of the Ave Maria alleged job offer in 2002. The fact of the matter is, your time, and good afternoon.
Ladies and gentlemen, Mr. Fiewiger has 9 minutes left. Do you want to take a stretch before he addresses you? You may do so.
The building, but the faculty are on the fourth floor. That's where they have lunch. That's where their offices are. That's where they go after classes. Okay. So she asked, so what do you have? Is there something on the fourth floor I don't know about? Well, that's when, I heard somebody talk about this. Or, I was walking down the hall and somebody said, oh, she's just a right to life. Or, we can't have that. But Professor Carlson had nothing for the dean to act on. And that's what she did. She went to the person who sent the email in a timely manner and asked, what is this? But then there wasn't anything. Now, what did she also have at the very same time? She had objective evidence on why Ms. Wagner wasn't recommended, because of the job talk. So she had her own evidence to say, there's a perfectly good reason why she wasn't recommended, and I don't have any facts to go look into. No, you're not giving me anything, Professor Carlson. I read your email, and I took it seriously, but you're not giving me anything to look into. The comments that Professor Carlson, her ally, obviously had some discriminatory basis because of the Ave Maria alleged job offer in 2002. The fact of the matter is, it wasn't then, it was just recently, unranked, unaccredited law school. It did not have the credentials that the University of Iowa would even think twice about. And all Professor Carlson was basically saying to Ms. Wagner is, it's really not a good idea to tell somebody you had a job offer that's 4 years old from this school. It won't do you any good. And it might as well have been Yale or Harvard, because it wouldn't do you much good to say, oh, by the way, they wanted me, and so you should want me. How about this? Answer the job talk questions correctly, and we won't care about what you did before. The comments that they attribute to Professor Bizanson, that was during the deposition Mr. Fiewiger took of Professor Bizanson. Those comments aren't very specific. It's possible her politics were discussed. It's possible. Well, that's the time then and there. If this man's being so candid, who talked about it, what was talked about, when and where. None of that is in this record. If there was any such discussion, which everybody says didn't occur, there's no more detail than it's possible. And we already have those possibilities in the sense of, are they going to hold my politics against me? Those conversations did occur because she brought them up herself. And when we look at the evidence of why we discriminate, it's because our faculty is registered as Democrats. It's because some of them are pro-life, pro-choice. We don't know on every one of them. Well, I submit to you that Ms. Wagner is imposing her political beliefs on the University of Iowa in an unacceptable way to say, because you faculty member are a registered Democrat and you've been a liberal, there's something wrong. And that's wrong because every one of you has the absolute right to hold your views and on your own, personally, privately, or publicly if you want. But to submit that because you're a registered Democrat, you couldn't be fair-minded to others. And that's what they're trying to submit. And I reject that. And so does Dean Jones. Briefly on the issue of damages, if you get there, remember she's worked part-time for us, half-time. That's the same salary, that adjunct salary. So the adjunct, if that adjunct's at issue, which I don't believe it is, she has no wage loss there. I submit to you in conclusion that Dean Jones is a fine, credible, accomplished scholar and dean at the University of Iowa, and she did nothing wrong in this case. And that I ask on her behalf that you return a verdict in favor of Dean Jones. I thank you for your time, and good afternoon.
Ladies and gentlemen, Mr. Fiewiger has 9 minutes left. Do you want to take a stretch before he addresses you? You may do so. Mr. Fiewiger.
Thank you, Your Honor. Mr. Carroll talked about what did Dean Jones do wrong. Well, she was president of Job Talk, where Carolyn Sheeran admits that they talked about her pro-life position. What else did they do wrong? She was at a faculty vote where Mr. Vizanzin said, yeah, her politics came up. We were talking about her conservative politics when the decision was being made whether to offer her a job as a full-time instructor. Yep, I believe that. I believe that her politics were talked about. She didn't stop that process. That's what she did wrong. What else did she do wrong? She got an email from her associate dean, John Carlson, spelling out that his takeaway or his impression, or whatever you want to phrase it like the professors did, was that they were talking about her politics, and there was this undercurrent. And they so despised her politics, it was clear to him, as a person who'd been there for 30 years, that she can't get a fair shake. What do you have for that? I don't know, whatever. Did she go and investigate that? Did she go and talk to any of the faculty members to see if that's true or not? No. She just let it slide. She just let it go. Because in country clubs, you tend to pick the people that you want to be with who are like you. I don't know if any of you are aware of past history, but in this country, Jews, Catholics, African Americans had a difficult time in getting into country clubs, getting into professional organizations, getting into groups that had these secret ballots that required a 2/3 vote, that required that you don't quote, talk about it, but you sure do have it on your undercurrent. That's been somewhat blown away from the 60s, 70s, 80s onward. But now we still have it. And we have it in a situation that's the exact reverse. We have a situation where a conservative, politically minded woman can't get considered to be hired at the Iowa School of Law. In fact, it's historic now. They said so. That's what's done wrong. She didn't serve as the proper police person to make sure that the process was fair and reasonable. I went through Ms. Wagner's job talk in great detail, not because I didn't want to talk about other things. I did it because I wanted to show you exactly what she recalled happening there. And when you heard those instructions given by the judge, he said, when you weigh evidence, you don't weigh it by the number of people who testify. You weigh it based on those credible witnesses who can recall factually what happened. Not the gist of it, not my take on it, that I thought that this is what happened. It's what was actually happening at that time. And Ms. Wagner's ability to recall what she did was never, ever impeached. When she went through and said, this question was presented and this is my answer, this was the next question, this is my answer, Mr. Carroll never got her to ever show that she did something different. In fact, Mr. Bezanson agreed with me. If you saw me time and time again when I was questioning all the professors, and I was asking, is this the first question that was asked by Mr. Bezanson? And then, is this the answer she gave? And everybody was saying, yeah, that was possible. So did Randy Bezanson. I asked those questions because that's what happened. Not what they're trying to convince you of now, 5.5 years later, with a destroyed videotape. With a videotape that should have been preserved by the dean the minute she knew that there was politics being in play here. A videotape that if she claims she didn't hear politics being talked about on January 25th, 2007, should have damn well been preserved the next day when Carlson sends that damning email. Did you notice in Mr. Carroll's closing argument, he didn't mention anything about the videotape being the best evidence. He just continued to say these professors were all right and Teresa's wrong. Don't let them do that in this case. Use your common sense. Again, if a reasonable dean who's in charge of the hiring decision hears that politics are being talked about as a potential reason for eliminating her not only from that position that they voted on that day, but from any consideration in the future, you better police it. And she didn't do that in this case. Wagner did talk about analysis. The two most important constants in her outline, Linda Edwards' reading, Legal Writing and Analysis, and Deborah Brichot's The Aspen Handbook for Legal Writers. You saw the book. She showed you how she went 2 pages in that chapter and discussed that and incorporated that as part of her outline. Do you think this meticulous woman who you've heard testify repeatedly about what she did to prepare and what happened didn't follow her outline? Didn't even mention these things? That's not believable. Students not just absorbing new info, but being asked to process it, analyze it, and then present this in writing. A number of professors who testified here said she never even mentioned it. Never even said a word about analysis. How about her analysis section where she talked about active reading and explained to you in detail what that meant? I'm not going to go through it again, but again, they're saying she gave it short shrift. She didn't even talk about it when the outline shows she did. Further, the definition of analysis, which is in 197, shows that what she talked about was what was there. Issue spotting, identifying legal relevant facts, synthesis of legal rules. She did all that. She told them that she was doing all that, and yet they have to come up with a reason, so they do. That's just like when you're going in the country club and you're saying, I want to join. And are they going to tell you, well, you're not getting in because you're a Jew? No, they're just going to tell you the vote wasn't even close. That everybody says that you're a bad candidate for this. Well, that's the same thing that's happening here. You heard Dean Jones say, and I really, really, really wish we had that tape. Dean Jones allowed her agents to recycle that tape. You will recall that I put in Exhibit 132, the tape of another interview, of another person at the School of Law. The best evidence of their policy, recycle 1 year. Dean Jones couldn't identify what the exact policy was, or practice, or procedure. But she did say that we hold these videotapes all, whether it's an interview, whether it's a lecture, whether it's a visiting professor, we hold them all the same, according to our custom and practice. Well, the best evidence of the custom and practice is that you recycle these tapes in 1 year. What'd they do here? They recycled it 2 weeks or 3 weeks after they rejected her for the second time. Common sense. Do you honestly believe that if Teresa Wagner had given that stunning answer that she would not teach analysis, that Dean Jones would have done nothing to preserve the tape to memorialize that stunning answer?
Mr. Feewicker, do you want to wrap up your tape?
I do.
Exceeded your time.
We ask you to look at this from the standpoint of what we've proven that happened contemporaneously as opposed to what happened after the fact. And that Dean Jones admitted that she had the ability to hire someone whom the faculty had not recommended, but in this case chose not to do so, not only in January 2007, March of 2007, April of 2008, and January of 2009, and treated Ms. Wagner differently than other candidates based on political beliefs. Thank you very much.